Today's topic is the Virginia Consumer Data Protection Act, otherwise known as the VCDPA, and some of what you need to know from an information governance perspective. First, we will describe some of the law's background. Then, we will discuss some of the rights granted to consumers under the VCDPA. We will also discuss who is subject to the VCDPA and some of the exceptions to the law. Finally, we will address some of the important information governance aspects of the VCDPA and how our team of experienced information governance professionals can help to promote your compliance. Let's go. The VCDPA was enacted by Virginia's legislature on March 2, 2021, and is slated to come into effect on January 1, 2023. After California's law, it is the second comprehensive Consumer Privacy Act to have passed in the United States. In creating the VCDPA, the drafters borrowed various concepts from the European Union's General Data Protection Regulation or GDPR, as well as the California Consumer Privacy Act of 2018, or CCPA, and the recently enacted California Privacy Rights Act of 2020 or CPRA. The VCDPA applies to any entity that conducts business in Virginia or produces products or services that are targeted to Virginia residents, and that 1. Annually controls or processes the personal data of at least 100,000 Virginia residents, or 2. Controls or processes the personal data of at least 25,000 Virginia residents and derives over 50% of its gross revenue from the sale of personal data. There are a number of exceptions, however. First, the law does not apply to political bodies and agencies of the state, financial institutions subject to the Gramm-Leach-Bliley Act, entities that are regulated by the Health Insurance Portability and Accountability Act, and institutions of higher education. Also, the VCDPA does not apply to data that the controller, 1. processes as a result of a legal requirement. 2. Where the controller seeks to use the data to defend legal claims. 3. The controller uses for the purpose of fulfilling a consumer's request or for a consumer's safety or security. 4. The controller is conducting either research in the public interest or internal research to improve products and services. Or 5. When the controller is performing internal operations that can be reasonably anticipated by the consumer. Other excluded data categories include information subject to HIPAA, information relating to human research subjects, credit information, personal data covered by particular federal laws, and data collected about a controller's employees or independent contractors that is used in relation to their roles. Now, let's discuss the VCDPA from an information governance perspective. One area of interest is the requirement by controllers to conduct data protection assessments for certain processing activities, including targeted advertising, profiling, sales of personal data, the use of sensitive data, and activities that present a heightened risk of harm, which is not defined, thereby suggesting broad applicability. Controllers must then provide such assessments to the Office of the Virginia Attorney General, on request. Another area of concern is de-identified data or data for which certain details have been removed to make it no longer identifiable. Under the VCDPA, controllers who handle de-identified data must take protective measures to ensure that it cannot be re-identified, publicly commit to maintaining and using such data without attempting to re-identify it, and contractually require any recipients of de-identified data to comply with these requirements. Also, businesses subject to the VCDPA should analyze the scope of data that they share with third parties, including sensitive data, the categories and purposes for which they process or share data. Based on this analysis, businesses may need to review and possibly redraft their policies, staff training materials and procedures to ensure that consumers can opt out of the use of their personal information for purposes prohibited by the VCDPA. Businesses should also verify that their staff provides consumers with all personal information that the business has collected about them. Our team of experienced information governance professionals can help you review and draft your policies in a manner that promotes VCDPA compliance. provide staff training, and help you identify areas where your infrastructure can be improved so as to increase your ability to handle client requests under the law. Contact us today to discuss how we can help you achieve information governance compliance.